ea ka aha ho kolo kolo ki ike hano hano u a ko koa ho maila. This Honorable Supreme Court is now reconvened. Inoho ilau. Please be seated.
All right, please call the case.
Case number SCWC-22-0000349. In the matter of tax appeal of Hawaiian Airlines, petitioner plaintiff appellant versus Department of Taxation, State of Hawaii, respondent defendant appellee. Arguing for the petitioner Hawaiian Airlines, Thomas Yamachika of Aloha State Tax. Arguing for the respondent Department of Taxation, State of Hawaii, Mary Bong Yokota, Deputy Attorney General. Also appearing is Nathan Chi, Deputy Attorney General. Argument on the merits.
All right, good morning, aloha everyone. Our proceeding today is being broadcast live on our YouTube channel as well as on Olelo. Counsel, are you ready to proceed?
Yes, Your Honor.
All right, so we've allowed 30 minutes argument for each side. Mr. Yamachika, you've reserved 5 minutes for rebuttal, so we'll give you a warning with 25 minutes in. Ms. Yokota, you have 30 minutes. We'll give you a warning with 5 minutes to go. Mr. Yamachika, please proceed.
Thank you, Your Honor, members of the court. Tom Yamachika, proud to represent Hawaiian Airlines this morning. Underlying this case is a classic tax dispute. We think a tax exemption applies. The department doesn't. But this case isn't about who's right. It's about whether we can even talk to the referee before they keep our money. The department audited Boeing, which was selling parts for our aircraft, and which made clear that if general excise tax applied, it would be passed on to us, like most retailers anywhere in this state. Early in the audit, the department told Boeing that the exemption did not apply. Boeing told us, and we submitted facts and argument to the department, and they manifested their answer in a number of ways, all of which occurred before suit was filed.
I'm sorry, I couldn't hear the last thing you said.
And the department's answer was manifested in a number of ways, all of which occurred before suit was filed.
Thank you. Yeah, it's a little echoey that occurred. I don't know if there's anything you can do about it. But...
Okay, maybe I just adjust this guy. All right.
Let's give that a try. Sorry, Mr. Yamachika.
Not a problem. There is a notice of proposed assessment here. This is record of on appeal number 69, dated in May 2021. It says the audit's been completed. You must take action within 30 days from the mail date. If you agree with the assessment, please pay up. If you don't agree, you may appeal in accordance with the Hawaii Taxpayer Bill of Rights. That's what this says down here. And the Taxpayer Bill of Rights is actually printed on the next page of this this exhibit here. And it says in part, in lieu of filing an appeal, the taxpayer may pay the disputed tax assessment under written protest and seek to recover the taxes by filing an action in tax appeal court within 30 days from the date of payment, which is what we did. Now there's more. At the same time, the auditor sent a letter that accompanied the notice of proposed assessment. It was sent to an officer of Boeing on department letterhead, signed letter, saying that the audit is closed and the aircraft maintenance exemption, which is what we were relying on, this is item number 3 here, is disallowed. The letter further directed Boeing to file or amend any filings after the audit period, according to the audit findings. So it's not just expressing a decision for the audit period. It's basically telling Boeing, and you must toe the line thereafter.
You must what? I'm sorry.
Toe the line.
Gotcha. Okay.
And if that's not enough, we see 6 months before that, in August 2020, this is record on appeal number 75. It's an email from the department's official representative, the auditor, which says, we disagree with your customer's interpretation. Our position remains the same. Resplendent use of the royal we to convey to whoever was reading the email that it wasn't just the auditor's opinion, but it was the considered judgment of the department that this email was expressing.
Counsel, I'm sorry to interrupt you. Can I ask you, was there a significant difference between the proposed assessment and the final assessment that came out in July? I thought there was some difference in the numbers. It didn't seem to be significant, but other than that, was there any real major differences between
There was
the
no
two?
difference in the numbers, none. The only difference was that in the notice of proposed assessment, I believe the taxpayer's name or address had a typographical error in it that was corrected, so there was an amended proposed assessment issued, and then the notice of final assessment came out 30 days after that.
All right, so the May 21st proposed was actually the final.
In effect, yes. The question really is whether any or all of these documents evidence a dispute within the meaning of section 40-35. And 40-35 being the statute that we relied on for jurisdiction in the tax appeal court.
Counsel, if we were to agree with your position that at least one of these documents, perhaps a notice of proposed dismissal, would qualify under the Grace case, what relief are you requesting here? Because you did file the notice of the other case, and it appears that the tax court, of which we can take judicial notice, obviously.
Yes,
It
of
appears the
course.
tax court has actually ruled on the merits of the issue already?
Yes, the tax court has ruled on the merits. They did rule against us. We did appeal that.
Right. So what relief would you be requesting here? If we ruled in your favor on the procedural issue here, what are you asking, that we remand to the tax court for an adjudication on the merits?
I believe that would be appropriate, Your Honor.
Which they've
on
already,
the second
the tax
case,
court has already made.
on the second case, we also note that the state has filed a cross appeal challenging jurisdiction of that case as well.
I see. So they're challenging jurisdiction of that case also.
Yes,
I
mean,
see.
we commenced this case based on the 40-35 theory.
Right.
The second case, after this one was dismissed, we didn't want to, forfeit our money that easily. So we commenced the second case under 232-14.5. And that one did reach the merits under Judge Chang. But when Judge Morricone heard it, he decided that the state had the better argument on the merits, which we don't agree with, by the way.
But they're alleging lack of jurisdiction there, or was it the statute of limitations argument? I'm a little confused. What's the basis of the argument that there's no jurisdiction in that case?
In that case, they are contending that we filed too late.
Too late.
Yeah, in this case, they're saying we filed too early. The other one, they say we filed too late.
What are they saying? What's the allegation? Was it the statute of limitations? Are they alleging like a 6-month statute of limitations? I'm a little bit unclear. What's the allegation as to why that one was too late?
The issue is 232-14.5 grants jurisdiction when a refund claim is filed
Right.
and the department either denies it or doesn't act within 6 months. And they said, I believe what their argument is, and they can probably clarify that further, but I believe what their argument is that, well, of course we denied it. And you didn't file within the 30 days, so you're out of here.
30 days of like a deemed denial after 6 months.
Yeah,
is that right?
well, I think they are saying that there was a deemed denial somewhere before the 6 months, and we don't really know when.
Okay.
But
thank
that's
you.
kind of something that
Obviously,
they can.
that's not before us, but I wanted to see if you had a clear way of addressing the merits in another case, and you're indicating that that's not clear right now.
It's not clear right
Okay,
now.
thank you.
Why don't you address the Grace case? And do you think we need to overrule it, or do you think that we can reach the outcome that you're suggesting consistent with the principles that our court set forth in this appeal of the Grace case to this court?
Well, Chief Justice, I think that the Grace case does need some tweaking. Okay, it tried to do a good thing. It tried to set forth some clear rules for cases, but it talks about a formal administrative decision as opposed to a final administrative decision.
Right.
And we're really not sure what is meant by a formal administrative decision. Now, and the examples that were given in Grace were a notice of assessment and a ruling and a denial of refund. One of the examples just doesn't make sense. If you take as a signpost the denial of refund, for example, you can't pay under protest. The money's already been paid. So that example is not helpful at all for practitioners.
So you think we should clarify or explain further what formal administrative decision means, correct?
Absolutely, Your Honor.
Okay.
I think that would help create clarity in the profession.
And
Well,
what,
what if-
certainly-
I'm so sorry.
oh no, one critical factor here that's different from Grace is here that in Grace there was just an intent or the beginning of an audit. Here the audit's been completed. Could you explain why that might be significant in terms of a rule that we might, or clarification that we might provide? Again, and if I'm wrong, please correct me, but my understanding is in Grace, the audit hadn't even occurred. Here, the audit had occurred and the taxpayer had been told that the audit is complete.
Well, in Grace, Your Honor, there was a reference to a notice for proposed assessment having been issued at some point. We don't know when. We think it was issued a couple of months after the lawsuit had been filed, because the Grace opinion does give reference to suit being filed in January, and a couple of paragraphs down, it talks about a proposed assessment in connection with something that happened in March. Now, it doesn't say that the proposed assessment was filed in March, but it also isn't clear that at the time of the lawsuit that the proposed assessment had been issued.
Well, that makes our case more similar to that case. What about the audit? Again, isn't that was, if I read the Grace?
What we do know, Your Honor, is that in Grace, the audit was not completed. Here, this says it is.
And why would that matter? Or can you explain, again, help us understand the relevance of the audit in this context? And why-
Certainly, because one of the things that the court said in Grace was that they were trying to make sure that the courts not get entangled in the audit process. Okay, that was one of the big policy considerations. So we don't have that here. The audit's done. This letter says, this notice says the audit's done. The accompanying letter says the audit's done. Everything says the audit's done. The department made up its mind.
Does the department always issue a notice of proposed assessment like this?
This is
After an audit?
um,
Because Grace really was dealing with an audit situation and whether you could do it, under formal administrative decision. What if this court were to hold that it includes a proposed notice of a proposed assessment?
we think that would be entirely appropriate, Your Honor, because this is a form document that the department issues. It comes on letterhead. It's officially signed, in facsimile, yes, I'm supposed, but it's still officially signed.
Well, not only that, it says you must act within 30 days and it
And you must
attaches
act
the Bill
within
of
30
Rights.
days, yes.
Right, and the Bill of Rights also has direction on how to file the protest. Isn't that right? And that was attached to this very letter.
That's absolutely right. That's the next page of this exhibit.
And I'm sorry, I misspoke earlier. What I was trying to ask you was the difference in numbers. It was between the May 20th, 21 letter and the attachment. It has a balance there. I think it was like 1.954. And I'm not sure if that balance represents what's
Oh, okay.
owing.
There
And then
is
on
a,
the-
there
excuse
is a
me, let me finish.
significant difference.
Let me finish, please.
Yes.
The next one is May 21st letter, and that one is 1.965. And I was just wondering what that difference is, if it's even a significant difference.
Your Honor, I'm not aware of any material differences between the two notices of proposed. There is a difference between that and the final because it reflects our payment.
I'm just talking about the May 20th letter and the May 21st letter. The numbers don't seem to jibe, but maybe I'm misreading it.
That I'm not sure of, Your Honor. The official assessment is this one.
Thank you.
And
You actually were
yes,
not,
there were schedules accompanying this letter, but this is the official proposed assessment.
weren't there other amounts not related to Hawaiian that was also included here?
That's correct, Your Honor.
Right, so in terms of the amounts allocated to the Hawaiian, you paid 1.6 something, is that right?
1.6 million, yes.
Right, so there were actually additional amounts assessed that have nothing to do with your Hawaiian's liability for.
That's absolutely correct.
Right, okay. So perhaps the difference might have related to somebody else's obligation, Boeing's obligation or another airline's obligation.
That's correct. I mean, Boeing was selling not only to us,
Right.
If I
but
could,
they had other customers in Hawaii.
if I could ask you this, in sort of just a general way, what, in your view, is the purpose of the proposed assessment versus the final? In other words, doesn't the proposed suggest that it's still subject to change? And that I guess I'm curious about setting a rule that maybe in this case it didn't change, perhaps, but in many other cases it might. So doesn't the proposed assessment still allow for the department to consider its position and ultimately come up with a different number?
Oh, certainly it does, Your Honor. Even after the final assessment's issued, you can petition for audit reconsideration, and they can reconsider the audit and change the number.
Right, so though if a proposed assessment is considered the, formal administrative decision, and by the way, Grace says notice of assessment, it doesn't say notice of proposed assessment.
Yeah, nor does it say notice of final.
Right, it says adverse ruling, and I think you're arguing perhaps that it's an adverse ruling, but doesn't that counter the underlying analysis in Grace that the court was trying to preclude or prevent, consistent with the declaratory action statute, that actions are not subject to challenging tax issues? How do you explain that? How do you reconcile your position that the tax could change, but that it still would trigger the ability to go forward under 4035?
Well, as we read Grace, Your Honor, the tax could always change. It doesn't have to be fixed at the proposed. It doesn't have to be fixed at final. It can be, there is the possibility for a petition for audit reconsideration. The question is, what is a formal administrative decision? And, okay, so what are the trappings of formality? Well, we got the letterhead, we got the official signature, okay? We have nothing within the body of the letter says it's tentative, except, the word proposed.
It's not the trappings of formality that I'm asking about. I'm asking about how do you square what you're suggesting, that this proposed assessment is sufficient to allow you to go forward under 4035 when Grace was concerned about not requiring a DEC action. You have to file your 4035 action within 30 days. Is that correct?
Within 30 days of payment.
Right, of payment. Okay, and you got to pay it. Oh, so how would that work then under your analysis, the timing?
So when we have a concrete dispute, 4035 allows us to pay it under protest and go to the referee.
So just pay the proposed assessment.
That's what the department thinks is the answer. The department's saying the audit is closed.
How long typically between a proposed assessment and a final assessment? Are there requirements as
My
to that?
understanding, Your Honor, is that if you don't do anything in response to the proposed, the final issues automatically by computer in 30 days.
30 days.
And it will issue in 30 days unless somebody goes in manually to stop the computer from doing that. So it's pretty automatic.
Well, pretty automatic now, but that notice though does say that the tax assessed, it's gonna become final in 30 days, right?
Yes,
And
that's what it
you
says.
have the right to clarify or object or say whatever you want, right? How's that a final administrative decision then?
I don't know if it's a final administrative decision. It's a formal administrative decision.
Okay, and that's what I'm sorry, I meant formal administrative. How is it though? How is that a formal administrative decision when it's still up in the air?
It says the audit's over. It's on letterhead. It has the trappings of formality. I mean, you're right, Justice, in that there is, I think, a tension between the concepts of formality and finality. And it just so happens that Grace used the word formality and it didn't use the word finality. So that's kind of what we're working with.
And I want to ask you, sort of riffing off of what the Chief Justice said, I mean, is there an impact here with respect to the audit? The fact that an audit was completed in your situation, but not in the Grace 2 situation?
Our position, Your Honor, is that it doesn't interfere with the audit because, it says right there in black and white that the audit's done.
There's a very interesting majority opinion by Judge Lim in the Grace case, which talked a lot about the history of the statute and policy issues, which are alluded to in our court's opinion about the possible impact on the taxpayer of uncertainty. What are your understanding of some of the policy issues at play here? Why is it important for taxpayers to have the ability or right to pay up? It's very interesting. Ordinarily the government is trying to make people pay up, and here we got somebody paying up, and the government's saying, "Well, you paid us too soon." It's a bit of an unusual circumstance. So, what's your take of why? If you look at the statute, there seems to be a little room of a little bit of play in the statute. What are some of the policy considerations that are going on here that would suggest that maybe we want to give a little more flexibility for taxpayers to be able to pay and then contest?
Well, the history of 40-35 was also reviewed quite at length in Captain Andy's Sailing. And Captain Andy's Sailing made the point that the statute is designed to be remedial. You had government agencies taking money away from citizens, and it was thought by the legislature at the time that you needed to have some way to get to the referee, so that, and let me just kind of wax poetic here for a little while. One of the things that government has to do is to raise revenue.
Is to what?
Is to raise revenue.
Okay.
They need money. I mean, somebody's got to pay you guys. And if they're going to do that, they have to rely on their citizens to give them that money, through taxes, fees, whatever. And if the citizenry thinks that the process for extracting the money out of them isn't fair, you're not going to have a society for very long. So I think it's really important to have a system where the citizenry is assured that the system is fair. And if they have any complaints about it, they can go to the referee.
But why this process? I mean, why not just say, hey, you can do I guess you could, I suppose you could pay and do a refund. What is it about this particular process as opposed to any other that might have been an option for Hawaiian in this case?
Well, this option was selected, Your Honor, because at the time, we didn't have complete information about, what the notice of proposed said or what the notice of final said. They went to Boeing. And as Justice McKenna observed, the assessment had other issues in it, which really were none of our business. So we had to have some way of figuring out, how much was our part.
Basically, Boeing told you this is what you have to pay,
Yes.
right?
With a schedule that was prepared by the auditor. So they had
With a what?
With a schedule, a spreadsheet that was prepared by the auditor at Boeing's request. So Boeing had, the billing, and part of the support for the billing was the auditor's schedule saying, these sales are attributed to Hawaiian.
So you actually didn't receive this initially, but under the statutes there's a statute that you cited saying that you step into the shoes of Boeing for this purpose. Is that right? I mean,
Yeah,
you
under
get
232.1, as indemnitors,
you
it
get
was
the
our
rights that
injury.
Boeing had,
Right.
right?
We're basically subrogated to the taxpayers' rights
Right.
for what we have to pay.
Putting aside your business relationship with Boeing, if Boeing or Hawaiian had not paid Hawaiian's share, what would have been the deadline? Assuming you didn't pay, assuming the formal assessment came out, the final assessment came out, then how long would Boeing and or Hawaiian have had to pay that before? Is there like interest that accrues?
Interest is always accruing
Accruing from what point?
from the date of the return.
The day of the return. So I see. So by paying early, you were limiting interest because the return was several years previous to this.
That's absolutely
So
correct,
by
Your Honor.
paying early, you were trying to limit interest obligation. Is that right?
I think that was part of the calculus.
Part of the
yes.
analysis. And what is the interest rate that's charged?
8%, whereas refunds pay 4%.
I'm sorry?
Refunds are paid 4%. Deficiencies in tax are charged 8%, which is
see.
double that rate.
I see. So
Refunds, you get 4%. If you succeed on the refund, you get 4%.
We would hope so, yes.
Okay, I'm just in general, not you particularly, but that's the provision.
Yes, that's correct.
I'm sorry to mean it.
yeah, yes.
And I'm into our rebuttal time, so I'd like to reserve some time for rebuttal, and thank you, Your Honors.
All right,
Thank you.
very well. Ms. Yokota.
Good morning, Chief Justice and
I'm
Associate
going to pull
Justice.
the mic down just a little
Down a
bit.
little bit further.
And keep trying.
Does that work?
Kurt, is that good?
That works.
Okay.
Okay, thank you. Good morning, Chief Justice and Associate Justices. Wow. I am Mary Bong Yokota, a Deputy Attorney General, appearing on behalf of the Director of Taxation. At issue before this court is whether the Tax Appeal Court had subject matter jurisdiction under HRS Section 4035. Based on the statute, legislative history, and this court's opinion in Grace Business Development Corporation versus Kamikawa, 92 Hawaii 608, our position is that it did not. I think it's actually quite relevant to go through the legislative history and the language of the statute. HRS 4035 allows a claimant to make a payment under protest, but only for any disputed portion of monies representing a claim in favor of the state, and to bring an action to recover such payment. The statute expressly provides any action to recover payment of taxes under protest shall be commenced in the tax appeal court. As explained in Grace, HRS 4035 was enacted in 1907 and was specifically amended in 1967 to require that the payment under protest be disputed. When an action is brought under 4035, the payment is held in what is called a litigated claims fund and cannot be withdrawn until that suit is resolved. In 1967, the legislature was concerned that claimants could include monies that do not relate to the issues actually in dispute, and thereby handicap the government by making the monies not available for use. The dispute requirement was added to address this concern by preventing monies which do not relate to the issues actually in dispute to be paid under protest under the statute. In Grace, this court found that absent a formal administrative decision, at the time of payment, there is no actual dispute within the meaning of the statute. Adopting the analysis of both the statutory and the legislative history in Judge Acoba's dissent in the ICA opinion, 92 Hawaii 659, this court found where an administrative decision has not been formalized, simply arguing that there is a dispute or a difference of opinion with the department policy and paying taxes under protest does not present an actual dispute under HRS Section 4035.
But in the facts of this case, there had been some back and forth as to the maintenance exemption, correct? You had considered Hawaiian's legal position, and the department had considered Hawaiian's legal position and rejected it, and then came out with this notice of proposed assessment, right?
That is
You issued that to Boeing, and then Boeing demanded that Hawaiian pay its share of about 1.6.
That is correct, that the proposed assessment was issued. However,
So I'm a little bit confused. So basically, in this case, you're saying that this was paid too early, so they don't get it back. And in the refund case, you're saying that they filed too late, so they don't get it back.
I have to clarify, I think there was some mix-up in the question and answer previously. In the other case, it wasn't a statute of limitation per se issue. What was at issue was HRS 23740. And that limitation of time was not for bringing an action before the tax appeal court. It was actually the time period in which a taxpayer can claim a refund to the Department of Taxation.
Okay, so they didn't claim a refund within 6 months?
It's actually not 6 months. It is,
It's within 30 days of the denial? I mean,
no, actually, when an annual return is time filed or is filed within 30 days after the date prescribed for filing an annual return, the credit and refund shall be claimed within 3 years after the date the annual return was filed or the date prescribed for filing the annual return.
Okay, so
whichever
the
is
annual
later.
return had been filed.
Correct.
Boeing's annual return had been filed for more than
Correct.
So basically, you're saying that if a taxpayer that's subrogated makes a payment under protest prematurely, there's no way they can get their money back.
Your Honor, I think that goes back to the legislative intent of
To keep money if taxpayers receive a notice of proposed, let's say they're not even subrogated, let's just say they receive a notice of proposed assessment and the taxpayer bill of rights that says, in lieu of an appeal, you can make a payment under protest. And they make that payment, the Department of Taxation's position is that, too bad, it was too early, and you never get your money back.
Your Honor, I would like to make one clarification. The proposed assessment basically says to the taxpayer to act within 30 days. They have the option to reach out to the preparer.
What does act within 30 days mean? So payment is not acting within 30 days?
Oh, they have the option to pay it. That is
They did.
correct. But I think as it was brought out earlier, if it basically says if you disagree, you can reach out to the preparer, or you can try to seek an appeal in accordance with the Taxpayer Bill of Rights. I do want to make a clarification.
But if they don't pay, you will accrue interest at 8% for the entire disputed, 8% is not normal interest, at least as of that time, right?
Correct.
And so I'm having a lot of difficulty understanding what a taxpayer is supposed to do. It's like, I'm sorry, you paid too early, therefore, I'm so sorry, you can't, and since the return was filed more than 3 years before, so sorry, it's too late to request a refund, and you paid too early, so you can't get your money back. It belongs to the state. Where is the due process here?
Your Honor, I think, first of all, in regards to your concern about interest, the taxpayer does have other options. The taxpayer actually place a cash bond during the audit, so as to
How much do they
stop.
pay for a bond? I mean,
Pardon
I
me?
don't really know how much bonds cost
Oh,
for
no,
these
no.
types of things.
The
but-
cost is not, the cash bond is an administrative procedure in which a taxpayer can make payment simply to toll the interest.
Is
So,
that in the letter?
I believe that is in the TIRs, and information is available through the public. And I do want to point out that
What's the
when,
TIR?
Pardon me?
Taxpayer.
pardon me,
What is that in the Taxpayer Bill of Rights form?
my understanding is it is available in tax announcements and previously TIRs, which had been revised so as to make the process more efficient.
But for a regular taxpayer, how in the world are they supposed to know they can do that?
I would like to point out Hawaiian Airlines is not just a mom and pop store.
I understand.
It is a sophisticated taxpayer with counsel, if not multiple counsels. Your Honor, this is something that they should have known.
I'm sorry, go ahead.
I apologize. I didn't mean to interrupt.
No, I interrupted you, I'm sorry.
Oh, no, please. I think I finished my
Okay, I
sentence. Thank
apologize.
you.
Whether they're sophisticated or not, you send this letter, this May 21st letter. It goes to the taxpayer, and it says the audit has been completed. It says a response required within 30 days. And as far as what you do next, it says you must take action within 30 days. And then it says if you agree, pay. If you disagree, you can look at this Bill of Rights and you can see what you can do. And part of the Bill of Rights is you can make payment with protest, under protest.
Your Honor, I do want to make a clarification. An assessment is something that requires to go through a particular process, which is expressly set forth in HRS Section 237-36. An assessment is, in fact, the final assessment. The final assessment is a culmination of the entire process in which there is an audit and a proposed
they may
assessment issued.
That
And-
may very well be the case, but I'm just focusing on the information that a taxpayer receives. It's in the form of this letter. And it's saying you must take action, look at the Bill of Rights, and the Bill of Rights says you can pay with the underwritten protest, and you've preserved your rights at that point. And that's what they did.
The Taxpayer Bill of Rights refers to 4035 with respect to an assessment. At the point of a proposed assessment, there is no assessment at that time under 237-36.
But it doesn't say that in the cover letter. The cover letter refers to the Bill of Rights. And it's
Correct.
directing Hawaiian Airlines to look at that and see what your options are, and they followed that.
And I wanted to bring to the court's attention that the Taxpayer Bill of Rights actually includes other options, including an appeal to an administrative expedited process, which
Right,
does allow you.
but one of the options is doing exactly what Hawaiian did in this case.
I would
right?
disagree.
That's
What-
not one of the options?
The appeal option at the point of a proposed assessment is to appeal it to the expedited administrative appeals. And that is the appeal right that they have based on a proposed assessment.
Under section 7, it says payment under protest.
In section, and
7,
does it not indicate that it is pursuant to an assessment? It does not provide that you can file a 4035 based on a proposed assessment.
Well, that's what's, I guess, not clear. And it seems to be, seems to be an adverse ruling at this point when you look at the letter on its face with the attachments, and beyond just an abstract disagreement. So how do you respond to that?
Your Honor, the process of a proposed and a final is not limited to the circumstances and the facts of this case. It actually applies in a wide variety with respect to all taxpayers. The audit process does allow the auditor to communicate with the taxpayer and to have that communication to try to assess what the correct amount is. Not all situation allows for that free exchange. Sometimes the taxpayer may not be cooperative, and they won't be cooperative until the proposed assessment is issued, and only then will they come with further information that ultimately results in the final assessment. Sometimes a taxpayer may not be able to find the information in time, and at times the department might have to proceed with a procedure based on best information available given the statute of limitation to assess. There are an array of circumstances in which a proposed assessment and a final assessment can be different.
Can I ask you this? Is this a form letter, this May 21st letter? Is that something where an unsophisticated taxpayer would receive this type of form letter? Is that what it is?
If you're referring to the proposed assessment, my understanding is it is pretty standard, correct?
So an ordinary citizen would receive this type of information as a form letter.
And an ordinary taxpayer often reaches out to the preparer to even seek further information as to what their
That's not my
options are.
question. My question is, would an ordinary citizen receive this same type of letter?
The proposed assessment,
Yes.
yes.
Thank you.
In terms of the Taxpayer Bill of Rights, there's section 6 deals with, discusses audits and assessments and talks about notice of proposed assessment, and then it says you have a right to a final assessment within 30 days. Then section 7 addresses tax appeals / payment under protest. And it says tax appeals, taxpayers have a right to appeal an assessment or a denial of a claim for refund to the Board of Review or to the tax appeal court. It says taxpayers have the right to appeal an assessment. It doesn't say have the right to appeal a final assessment. It says appeal an assessment, right?
Your Honor?
And then no, that's what it says, right?
Correct,
Yes.
correct.
And then it says, and later toward the bottom of that column, the second middle column, it says payment under protest. In lieu of filing an appeal, if an appeal is not filed, you can, let's see, payment under protest in lieu of filing an appeal, the taxpayer may pay the disputed tax assessment under written protest and seek to recover the taxes by filing an action in the tax appeal court within 30 days from the date of payment. Now, there's a parenthetical in there. It says, in lieu of filing an appeal, or if an appeal is not filed with the Board of Review, with the tax appeal court, or with the Administrative Appeals Office within 30 days from the date of the final notice assessment was mailed, okay? So it says, in lieu of filing an appeal from a tax assessment, the taxpayer may pay the disputed tax assessment under written protest and seek to recover the taxes by filing an action in the tax appeal court within 30 days from the date of the payment. Do you not think that that's confusing? Whether it's to Hawaiian or to Boeing or to a regular taxpayer as to what assessment you're talking about?
Your Honor, I am looking at the very proposed proposed assessment
And
that
it,
taxpayer.
doesn't that letter refer to a taxpayer bill of rights?
I am looking at the provision that Your Honor just read.
Yes.
But the copy I have actually said,
What's the date
within,
of yours?
within 30 days, oh no, I think Your Honor was correct. It actually says within 30 days from the date the final notice of assessment.
Where?
I'm sorry,
But
I'm looking
that's
at
the
docket
parenthetical.
69.
That
Docket
is a
69.
parenthetical. It says, in lieu of filing an appeal, or if an appeal is not filed with the Board of Review, with the Tax Appeal Court, or with the Administrative Appeals Office within 30 days from the date of final notice of assessment was mailed, all right? If an appeal is not filed within 30 days of the final assessment, then the taxpayer may pay the disputed tax assessment under written protest and may seek to recover the taxes by filing an action in tax appeal court. It doesn't say you may pay the disputed tax assessment under protest only with respect to a final notice of assessment. If you want that to say that, I think you need to clarify your language. But this language does not restrict this right to a final notice of assessment. And the prior paragraph section discusses notices of proposed assessment, and it talks about the final assessment. So it seems to me that the Department of Taxation has created confusion in the Taxpayer Bill of Rights. And I'm having a lot of difficulty understanding why the tax department takes a position like this in order to try to keep taxpayers' money.
Your Honor, I would like to state that under grace, this was a jurisdictional issue, and we did feel a responsibility to bring to the court's attention that there was a jurisdictional issue. We do not disagree with grace, and I cannot dispute with your opinion in regards to the drafting. I don't know that I would be able to comment on how it was drafted at this point. In regards to the assessment, I think the department does have to take the position that there is no assessment without a final assessment under HRS Section 23736. If we were to switch this around and have a taxpayer be provided with a proposed assessment does not actually create tax liability. Even if they are able to make a payment to stop the interest, it doesn't actually create the tax liability to which the payment can be applied. If, for example, a statute of limitation were to pass and the department only issued a proposed assessment, the taxpayer is not in fact liable for the taxes.
I'm sorry, I'm looking at 23736. Can you explain to me where it distinguishes between notice of proposed assessment and notice of final assessment?
Your Honor, under 23736, if I read this correctly, basically it allows the process in which an assessment can be made. And that process requires you as a step to issue the proposed assessment and to allow a taxpayer 30 days to essentially to meet and confer with the auditor. And only upon the expiration of at least the 30 days can the department actually make an assessment. Although the labeling is called proposed and final, at the end of the day, we're talking about an assessment that's not actually formalized until the final assessment is issued.
Well, may I ask you this? In grace, one of the examples of a formal administrative decision is an adverse ruling. in a case like this, let's talk about the specifics of this case. There was back and forth, right, between the parties as to what the positions were on this exemption. The proposed assessment was issued. It says it will become final if not challenged in 30 days, if no action is taken in 30 days. What downside, if we were to determine that the proposed assessment was an adverse ruling in this case where, by the way, the audit was completed and it's stated in the letter, what is the downside to the department if in fact that number is going to remain the same if there's no challenge to it? And I know you've gotten into language about, or discussion about definitions of the assessment and final assessment, but why is this not an adverse ruling?
Your Honor, my understanding of adverse ruling in the tax context, as recognized in Grace, was based on Aloha Motors. And in Aloha Motors, at issue was a denial of a refund claim. The taxpayer actually made payment by mistake. And at the time, the statute did expressly allow appeals of assessments and an action to recover the payment made under protest under 4035. But Aloha Motors didn't have the option, at least initially or at face value, because there was no assessment because they paid it under they made it by mistake, and they couldn't pay it under protest. The money is having already been paid. The court in Aloha Motors basically looked at the various statutes, and I will confess I had to read it over and over again and try to look at the case law that it cites too. But it basically says that the governing statutes do not rob the tax appeal court of its jurisdiction over adverse ruling. And when you look at the case cited there, and I believe it was that Aetna case, in Aetna, it recognized that a statute provided issues with respect to refunds and credits, the exclusive remedy is by appeal or action by 4035. So there was a window for the court to find that the tax appeal court had jurisdiction. It is our position that what Aloha Motors did is it expanded its jurisdiction expressly to include denials of refund claim. This case is not at issue. There is no denial of refund claim at issue in this case. So we do not believe that there was an adverse ruling to consider in the first place. But I will also indicate that Aloha Motors may have been superseded by HRS section 237.14.5, which expressly now provides for the appeal of a denial of a refund claim. That was enacted in 2005, I believe, and Aloha Motors was decided in 1988, and Grace relying on Aloha Motors was decided in 2000.
Well, I'm still looking for an answer to
I apologize.
Justice Ganoza's question.
Yes.
How are the interests of the state adversely impacted by allowing payment and appeal in the circumstances of this case where the audit was concluded and a preliminary or notice of proposed assessment had been issued? Again, we're trying to understand, because there's this alleged history that sort of talks about, well, people are just paying money into the fund, even though it's got nothing to do with the fund, which I'm going to see if there's anything I could find to explain that, because that sounds a bit odd. But, it's great if folks want to pay money into a fund. I'm not quite sure why they do that, but I guess they were. But really, what are the interests of the state, the policy implications of doing what Mr. Yamachika is asking us to do in this case? How does it affect or negatively impact the interests of the state? Because, frankly, we could probably read the language of the statute more expansively than this court did in the Grace case. Why should we not do so?
Your Honor, I'll try to address the question both Justice Ginoza and Your
I think
Honor,
that's what
just,
she was asking.
yes,
Right.
yes,
I'm
I'll
sorry.
try to
Yeah,
address that.
I hope I didn't make it
On
worse.
a, on a practical level, Your Honor, it does and can create a chilling effect for the actual audit procedure. And what I mean by that is if any communications, including a proposed, an email as taxpayer has brought to this court's attention in the middle of an audit, if any document could be considered an assessment, it would prevent the auditor from sharing the department's actual position, which would facilitate the productive discussion with the taxpayer in assessing the correct amount.
Well, that's a reasonable point. So let's assume we take that
Yes.
off the table. The prior email, the internal memo,
Yes,
take that off the table. Now we're just talking about notice of proposed assessment and a letter saying which says the audit has been completed. Okay, that's what we're talking about, the facts of this case. How, if we said this is a dispute, a disputed portion of monies, how does that undercut the interests of the state? I understand that it's problematic if during the audit process, anything you say could be used against you. Okay, now the audit process is POW. There's a notice of proposed assessment. Why aren't we at the point where you could fairly say there's a dispute?
Your Honor, under Grace, it was our understanding that you have to look at the circumstances at the time of payment. This court in Grace, we understood, basically said it was irrelevant to consider facts that occurred after the payment. At the time of payment, all we had was a proposed assessment. And although taxpayer argues that there is no difference between the proposed and final, you cannot know that until the final assessment is actually issued. And I think that was recognized by this court under Grace as well.
Let me ask this, like, let's say that, like a big corporation or something, directs money to mistakenly directs money and, everything's online now. So let's say that one of their in-house accountants or something mistakenly pays the state of Hawaii Department of Taxation a couple $1 million. It was supposed to go to California and they paid Hawaii. That's it. It wasn't paid under protest. There's, I don't know.
Oh, Your Honor.
Like the return was more than 3 years previously. I'm a little bit unclear. Would you return the money then? I'm just curious.
I do think the case law basically says if you miss the statute of limitations, even if it is deemed not proper, if the statute of limitation has run, you do not have the right to get your monies back. But I do like to point out that the taxpayer does have the right to request that refund within that statute of limitation, and that statute of limitation was set for that particular reason.
No, but I'm just saying, what if it's, okay, I'm so
sorry.
sorry. It just seems like it's very, very technical in terms of trying to get a payment, a mistaken overpayment or a mistaken payment back then, or a payment under protest. If it's not filed, you have to wait until the final notice of assessment, and you've got to, and what if they pay under protest on the 31st day? That doesn't qualify, right? Because it's no longer within 30 days. So then the department gets to keep the money if the return was more than 3 years before, if it was a payment for a return more than 3 years before?
All I can say is that when an action under 4035 is taken, the monies are put into the litigated claims fund. And my understanding is that it cannot be withdrawn until the resolution of the case, whatever the court may decide.
I see.
I have one clarification question. You referenced 237-40 as being the statute in issue in the other case regarding the time limit to claim a refund. That was the position of the state, I understand, and the lower court rejected that.
I'm not the attorney of record in that case, but my understanding is that we did make that argument and the court rejected it.
Okay,
And that's what's being appealed
That's the
as
question
well.
on
Part of,
appeal.
yes,
Okay.
correct.
thank you.
Ms. Yokota, we were asking you a lot of questions there during the time you reserved or the time you'd asked for a warning. So I'll let you wrap up now with any points that you'd like to make to finish your argument or
That-
anything you weren't able to raise that you think is important.
Thank you, Your Honor. I'll try to abbreviate as much as possible. In Grace, it made that determination upon very careful analysis of the statute and legislative history. There is nothing in this case, we believe, actually presents any basis to overrule or reverse that decision, or even to make an exception. And under Grace, we don't believe that there was a formal administrative decision which could have been brought under Section 4035. I think it's important to bring to your attention that Hawaiian Airlines really had all the information or could have gotten the information necessary to appeal. It is not because the law did not provide relief to Hawaiian Airlines. Hawaiian Airlines could have waited until the final assessment and essentially paid under protest and filed an action before the court. Alternatively, it could have also waited for the final assessment and filed an appeal directly to the tax appeal court. It had the option to pay, thereby tolling the interest, or it even had the option not to even pay at that point of the appeal.
Could Hawaiian have done that?
Yes,
Or was it, so Hawaiian would be able to do that in lieu of Boeing?
that is correct. As Your
Even
Honor
though-
had pointed out in 232-1, as one who is obligated to pay under contract, they would be able to file the appeal.
But then they would be liable for 8% interest if it was denied.
That is between Boeing and Hawaiian Airlines under their contract. The liability is of Boeing, and our understanding is that Hawaiian Airlines was paying it pursuant to the contract.
Wait, you wouldn't assess 8% on Boeing for
Oh.
being late?
I'm sorry, I thought I heard you say Hawaiian Airlines. You are correct. It would be assessed against Boeing, correct?
Right, so
Yes.
they, so they're a company upon Hawaiian relies for its business, would be liable for 8% interest. So you can see why they would want to pay under protest under a circumstance like this,
If they
for business relationship purposes.
Yes, but if they paid after the assessment, the monies would also be in the litigated claims fund had they filed an appeal. So they do have alternative means to seek relief. One was 4035, the other was an appeal under Chapter 232. We just wanted to bring to the attention that the issue really seems to be that taxpayers claiming that it didn't have the final assessment. That's the reason why it could not do it after the final assessment was issued. But Hawaiian Airlines could have gotten that information. It could have, during the contractual negotiation, included into their contract that Boeing be required to provide them with any information related to any taxes that Hawaiian Airlines was required to pay.
And what if Boeing inadvertently forgot to do that? What, they would have a breach of contract action against Boeing for failing to do that? I mean,
Well, at least there is a way of getting the information, because I think what taxpayer was arguing was that they didn't think that Boeing would be cooperative. But at the same time, when they did ask for it, Boeing actually cooperated. So not only in regards to whether to put some term into a contract, but they could have asked Boeing, but the record reflects that they didn't, because they just assumed that Boeing wouldn't share that information. I would like to point out that all that was necessary was to find out when the final assessment was issued, not the actual final assessment, because it was really Boeing that calculated the $1.6 million. And I would like to correct something on the record. It earlier in the opposing counsel's question and answer, I think there might have been a misinterpretation. There was a schedule that was attached to Boeing's billing to Hawaiian Airlines, but the actual calculation of $1.6 million was not the auditor's calculation.
Anything further to wrap up at this point, Ms.
Your Honor,
Yokota?
I think you gave me sufficient time. I thank you for the time. We respectfully ask that the ICA order and judgment be affirmed. Thank you.
Very well. Thank you for your argument. Mr. Yamachika.
Thank you, Your Honors. I first wanted to follow up on the, I think the great line or line of questioning from Justice Devens about the Taxpayer Bill of Rights and the follow-up by Justice McKenna on the Taxpayer Bill of Rights. You know, we did what the document told us to do. Now, certainly, there's law in this state saying that, you know, you can't make an estoppel claim against the department because they're sovereign. And that's from InRatePriceline.com and Medical Underwriters of California. But the difference we would suggest in this case is that, you know, Priceline.com was an action by the attorneys general. Medical Underwriters was an action by the insurance commissioner. The department itself wrote the Taxpayer Bill of Rights. So I don't think there is any, you know, prejudice against them by telling them that they have to abide by the same rules that they tell taxpayers. I feel very strongly about that. And to Justice Devens' point about, well, you know, this might not be a mom and pop taxpayer, but I think as government, this court wants to apply rules that apply to everybody, that apply to all taxpayers, you know, big, small, medium-sized, to the mom and pops, as well as to the so-called sophisticated taxpayers of the world. You know, the more landmines and traps that are set forth, you know, the harder it is for ordinary citizens to have confidence in their government. And, you know, I cheated a little bit. I sat in on the previous argument, and I know that this court has a policy, a well-settled policy, to afford litigants the opportunity to have the case heard on the merits where possible. Specifically, that's from Lewis versus Kawafuchi in the tax context, but there are plenty of cases that hold that, as Justice McKenna and Justice Devens explicitly said in the prior argument. Narmore versus Kawafuchi furthermore says that doubt as to jurisdiction should be resolved in favor of the court having jurisdiction, which I think is a great policy to follow here as well. And finally, I just wanted to kind of mention the procedural complexities that the state brought up. They said, well, we could have done a deposit in the nature of a cash bond. We could have done this. We could have done that. All we're trying to do, Your Honor, is we're trying to follow the instructions as best we know them to get to the referee. Thank you very much.
All right. Thank you, Mr. Yamachika. Thank you, Ms. Yokota, for your arguments today. The court will take this matter under advisement.
Eku Iluna, please rise. Ua ho'oku'u ia mai ne, kea aha ho'okolokolo ki ike hanahano o ka maku'aina o Hawaii. This Honorable Supreme Court of the State of Hawaii is now adjourned.